All right. Welcome back. Welcome back. We have a fun one today. And by a fun one, I mean we're returning to Braun versus Day, Janet and Lauren the Mortician versus the girlies. And it's fun because Janet and Lauren's attorney has screwed up so colossally. So it's such a massive error that the case could be over already. At least this case. They could still refile it in a different court, in a, you know, we'll get to that, but one way or another. But first, let's say hello. Good to see you, Reflections. For those of you who are new, I'm Joe. I'm an attorney. I'm licensed to practice in the state of Utah. This is in Illinois for now. We'll see what happens to it, but it, it's just it's bad. It's really bad, and like it reflects very poorly on Benjamin Lockyer, the plaintiff's attorney, but it really could have career ending. It's that bad. So good to see you, Paul and Linux guy. And so, in a little bit of stalling to let people show up. So, as a general rule, I avoid covering cases at least before trial if they're here in Utah. I've I've made a few exceptions. Like I did a live stream about the Ruby Frankie mess, but the criminal case was down in St. George. That's a long way away. That's practically a different state. Good to see you, cranky elder god. Uh, but generally, I I wait until it goes to trial if it's local, and I mention this because I've been consciously avoiding a rather massive criminal case up in Park City because that's really close. In good weather, I can be to that courthouse in under 25 minutes. It's really close. And there is a new case here in Utah that has transferred from Scotland that part of me is dying to cover it, but I'm going to wait until assuming it goes to trial just because as a general rule, I don't want to conflict myself out of the ability to work on cases if I get hired at a firm or a prosecuting agency or you know they just randomly want to hire me or whatever. I don't want to have a conflict created by YouTube and so you know like in this case in the Braun versus Day, there's no way I'm getting hired because, well, I guess I could pro hoc vice into, but yeah, and that's basically it. Cranky elder god, don't shit in your own nest. Don't I I generally say it. Don't shit where you eat. It's just I think good practice generally. Whereas like I didn't cover the Gwyneth Paltrow trial day to day, but I went up to one day of the trial, tried to get up there for the day that she testified, but I mentioned good weather. I can be there in 25 minutes. That was extremely bad weather. And so it's good to see you, Kevin Campbell and RW. Uh, yeah, that's That's something that Janet doesn't realize. Most of us, like I had never heard of anyone involved in this case. Well, back that up a little bit. I had before it was filed, but that's only because of the copyright shenanigans and Markey's coverage of it. But that's still Streisand effect. I would not have ever heard of Janet. I would not have ever covered Janet, but she has blown this up and it's hilarious. It's just absolutely hilarious. So, that being said, let's jump into it, shall we? So, once again, this is Braun versus Day in the District Court for the Northern District of Illinois. And we have a minute entry. Basically, this is kind of an order from the judge. It's not ruling on any of the motions, but it's the judge basically saying, hey, there's a problem. And you need to fix this problem before we move forward. And you may remember I caught this problem going over the complaint. I didn't know exactly the details of the problem yet, but to quote Emily D. Baker, I had questions, and the judge does too. And Linux guy, we know that being called Janet bugs her big time. She included it as part of the complaint. She hates it. And that's why we do it, because free speech. I can call her whatever I want, as long as it's not defamatory. And calling her Janet is not defamatory. I can call her that bitch in maybe Illinois, but probably not. I can call her whatever I want. And yeah, Runkle covered it. He's faster than I am on the draw, but hopefully I have a little bit more insight. Runkle, as most of you know, is a Canadian lawyer. He's in Alberta and Edmonton, I believe. I always forget if it's Edmonton or Calgary, but I believe he's in Edmonton. And he admittedly did not catch this going through the complaint, but frankly, he knows a whole lot more about American federal jurisdiction laws than I know about Canadian jurisdiction laws. If this had been a Canadian suit, there was no chance I would have caught it. And also in his defense, basically to quote Seinfeld, you yada yada through the best part. And generally, the jurisdictional statement is the part you yada yada over, because that's usually a nothing burger. There's nothing there that's usually interesting unless it goes wrong, which it has here. And it's just fun. I am thoroughly enjoying it. The Schadenfreude is real, and she deserves it. They both do. And Linz, good to see you. I agree. Damn it, Janet. So I think I've beat around the bush long enough on this. So before we look at this minute entry, let's go back to the complaint so that I can show you what I caught, what the judge caught, and why it's problematic. So remember, let's actually back up. Let's go through the rules. Benjamin Cano, I thought it was Wyoming. That isn't real. Except I have been to Wyoming. I haven't been to Canada, so I think you're right. But let's go back to the rules. So remember, we have covered Rule 8 of the Federal Rules of Civil Procedure many times. so I'm not going to pull it up on screen right now. But the pleading standards for a complaint. There are 3 things required in a complaint. There's a short and plain statement of jurisdiction, a short and plain statement of the facts that entitle you to relief, and then the prayer for relief. Those are the 3 sections required. If you don't have one of those, you fail. Of course, you can amend it usually, but I've complained before. This room is the hottest in the house, and it's getting me already. So where we are is the first of those requirements, the short statement of jurisdiction, because basically federal courts, there is the assumption that the federal court does not have jurisdiction to hear your case. The courts of general jurisdiction are the state courts. So here in Utah, it's the district court. In Michigan, it's the circuit court. In New York, it's confusingly the Supreme Court. But those are the courts of general jurisdiction. Those are presumed to have jurisdiction. But there are a number of things that grant the federal district court jurisdiction. So the presumption is they don't have jurisdiction, but they have presumptive jurisdiction on cases involving constitutional questions, on cases involving federal law, on in this case, it's between citizens of different states, and it is how it's worded in the Constitution itself. And for those of you who are new to this case, I've done a whole video on it, debunking a sovereign citizen, because sovereign citizens, one of their well-trod arguments is that this court doesn't have jurisdiction to hear this case because there's only 2 jurisdictions, common law and maritime. And it's like, well, first off, that's a misreading of the Constitution, but you're not even in federal court for this traffic ticket. So the presumption is that the state court has jurisdiction to hear this. But so if you want a more full explanation of federal jurisdiction, go watch my video. It's I think Real Lawyer Debunks Sovereign Citizen Claim About Jurisdiction, or something like that. So yeah. And thank you for the super sticker, RW. I appreciate it. And she can amend, but I don't know if she can amend around this. This could either be it gets kicked down to state court, but I think it's going to have to be dismissed if the problems are what we think they are, because number one, there's going to be a venue problem, I believe, in addition to the jurisdiction problem. And so, yeah, it just, it's a comedy of errors. Let's put it that way. And so basically, like I said, this is the diversity jurisdiction, which is a lawsuit between citizens of different states. And no plaintiff can have the same state citizenship as any defendant. So all the defendants can have the same citizenship as each other. All the plaintiffs can have the same citizenship as each other, but you can't have California on the plaintiff side and the defense side. It's all or nothing. It's what's called complete diversity. And good to see you, Pat's Cats, and G0FVT. I'm not even going to attempt that. So you have to have complete diversity, and the amount in controversy has to exceed $75,000. Presumably, that's met here because they're asking for more than $75,000, and it's not a some certain, meaning there's no contract, there's no, invoice from a body shop showing what the damages are. We don't know. It's for the jury to decide. So presumably it works. And it's perfectly fine. I'm just not going to attempt it unless you give me guidance. So normally, this is just a given, although the amount of litigation that there is about diversity and jurisdiction, clearly it's not as much a given as you'd think, although it is settled law. So lawyers should not be getting this wrong. This isn't just first semester law school. This is first half of first semester law school. So no one should be getting this wrong. And Mrs. Bees, I'm glad you're here. Thanks for joining. So we'll even see nature of the case, looking at the complaint. Paragraph 1. This is a diversity action asserting Illinois state law claims for defamation per se. So, they recognize it's a diversity case, but they have to because they're the ones that are pleading it. And there's a reason they're trying to claim Illinois state law. It's because Illinois doesn't have a very strong anti-SLAPP statute, although there's a few other jurisdictions they probably could have filed in that probably have a weaker anti-SLAPP law. Of course, California has a very strong anti-SLAPP law, which is what they're trying to avoid. And good reminder, Cranky Elder God, I usually forget until the very end. Do all the YouTubey things, like, share, subscribe, bribe your friends and family to do the same. And so getting into this, like I mentioned, we have the parties. This is where they're asserting the diversity jurisdiction. And the problem is, well, there's multiple problems. Let's just put it that way. So plaintiff Jeanette Braun, Janet, is licensed to practice law in Illinois and operating the law firm Braun IP Law in DuPage County, Illinois, and resides in Illinois on a part-time basis. You may remember me saying in the first video I did on this, when we went over the complaint, that you may remember me saying the word domicile, because your residence, especially your part-time residence, is not necessarily your domicile. And the domicile is what matters for your state citizenship for diversity purposes. And that's important because, once again, you need complete diversity. And I had questions. It's what's a part-time residency in Illinois? Do you spend your weekends there? Are you registered to vote there? Where's your driver's license, Janet? Probably not in Illinois. And the Braun IP law, as we'll see, may not be domiciled in Illinois either. Now, it says, Plaintiff Braun Law is a limited liability company organizing and existing under the laws of the state of Illinois, in Addison, Illinois. It may be organized under the laws of the state of Illinois, but that doesn't mean it is in Illinois. So or at least it doesn't mean its citizenship is Illinois. It's domicile. Because as we'll see, it's the members' citizenship that matters. Remember, in corporations, the owners are shareholders. In partnerships, they're partners. In limited liability companies, LLCs, they are members. And Jillian, I tend to agree with you. To once again quote Emily D. Baker, this looks like fuckery. It looks like he was intentionally misleading. He knew her citizenship, but he tried to avoid it. He tried to get it into Illinois. And of course, I do have questions about both his and Janet's ability to practice law. And I'll get into that in a minute. And once again, a very good point, Cranky Elder God. Do not contact anyone in this. Of course, with the girlies, if you would if you would normally comment on their videos, keep doing so. But this isn't a petting zoo. Don't pet the wildlife. So you can see, although I'm told this is problematic as well, that this is a false statement. But plaintiff Lauren Propson, Lauren the Mortician, is a citizen and resident of the state of Wisconsin. I'm told she's actually from Florida, but I don't know. I'm just told that. But it could be that she actually is a citizen of the state of Wisconsin, but resides in Florida because, as I mentioned, your residence and domicile can be different, especially if it's part-time like Janet's. But the domicile is where you intend to return, is the short and plain legal term for it, but we'll get more into that. And so the next problem, of course, is for Bekah Day. Upon information and belief, defendant Rebecca Day, née Box, is a citizen and resident of the state of Missouri. That's a problem because, as the judge will point out, you cannot plead citizenship upon information and belief. You have to state it as a fact. So information and belief, not good enough. Don't file until you know their citizenship. And so this is another problem. And they do the same with Caffinated Kitti. Upon information and belief, defendant KC is a citizen and resident of the state of Georgia. They that's also a problem. They don't know her name. They haven't included her name. The judge hasn't pointed that out. It's if I didn't know her name, I would have, upon defendant Jane Doe operating under the screen name Caffinated Kitti, and then amend it later to include her real name, except they know her real name because they included it, I believe, in the false wellness checks, which we'll listen to once we finish the legal discussion here. And of course, I'm just guessing that they used her real name because Caffinated Kitti rightly bleeps it out when she publishes the video because she doesn't want to dox herself, which is understandable. And yeah, I have no idea about this magistrate's temperament. Fairfax is Northern District of Virginia, isn't it? Or I just, watching Law and Lumber, he mentions that Judge Ascarati from the Depp v. Heard trial, she takes no prisoners. She just, wham bam, we're done. And I do think Rule 11 could be in play here. It's that bad. So, and then this is maybe the most problematic. Upon information and belief, defendant Jessica Vasquez is a citizen and resident of a state that is neither Illinois nor Florida. Upon information and belief, defendant Vasquez is a victim of certain crimes, and out of respect for her privacy, plaintiffs request to not directly plead Ms. Vasquez's current state of residence. Now, there's all kinds of nonsense in that. I don't think this would be doxing to say she lives in Georgia. And I say I don't think that would be out of bounds because in her comment on Ian Runkle's video yesterday, she says as much. She says, I don't get why they're tiptoeing around the fact that I live in Georgia. I'm very open about the fact that I live in Georgia. I made a video about moving to Georgia. I mentioned it many times on the Do We Know Them podcast. So this just isn't good enough. Now, you may notice they put not a resident of Illinois or Florida. Now, why do they bring up Florida? If Lauren the Mortician is a citizen of Wisconsin, Florida should not matter. They should have said she's not a citizen of Illinois or Wisconsin. But this shows that there's fuckery afoot. This shows that Mr. Lockyer knows that he pled the wrong citizenship for his client. But once again, upon information and belief is not good enough. And if they were concerned about this, if they were concerned about not giving away her location, there's an easy way to fix that. You file a jurisdictional supplement under seal. The judge even tells them that, as we'll see. You'd go, hey, judge, I'm not comfortable putting her residence out there. Can I do it under seal? And that way it's for the court's eyes only. And the court can be satisfied that there's diversity, that there's complete diversity. But they didn't, because they're not good lawyers. And then finally, upon information and belief, defendant Lily Marston is a citizen and resident of the state of California. Once again, upon information and belief, that is not good enough. But this looks like it's going to be a problem. California. And I mentioned that I'd comment on the quality of these lawyers, of Janet and Mr. Lockyer. Now, normally, I don't like commenting on law school rankings because, you know, there's a lot that goes into law school rankings, but there's also a lot that goes into law school choice. And, you know, I'm on the record. I went to the University of Utah, S.J. Quinney College of Law. It's a very good law school. It's not top ranked, but it's very good. I think the current ranking is 32, and there's roughly 200 law schools. When it comes to law school rankings, you kind of look at groupings. So top 6, you know, you can't go wrong. And that's going to be your Harvard, Yale, Stanford, NYU, you know, absolute top tier law schools. And then for some reason, it's top 14. And Benjamin Cano or Kano, Georgetown Law generally is top 14. Excellent, excellent school. And I don't know why it's cut off at 14 as opposed to 15 or 20 or 10 or whatever. It's just historical. And then you're kind of looking that 14 through 50 and then 50 through 100. And then after 100, you're looking at pretty poor schools. And after a certain point, after like 150 or 160, they stop ranking them individually. They just put 150 plus. Janet and Lockyer went to the University of Chicago Kent Cook of Law. I'm probably getting something out of order there, but it's in that 150 plus range. Now, there's all kinds of reasons people go to different law schools. You know, I've mentioned before, the number one student in my class at the University of Utah, he was admitted to Harvard, but for him, Harvard didn't make sense because he was already married. I think he started law school with kids. I know he ended law school with kids. He was from Utah. He intended to practice here in Utah. It made more sense for him to absolutely crush it at the U as opposed to going to Harvard for his needs. And for your non-traditional students, sometimes geography doesn't allow you to go to the best school. Sometimes, you know, if you're a non-traditional student, you need part-time, and that's not offered at most of the best schools. You're looking pretty low ranks for that. There's just all kinds of reasons. Some people can't do it. Static, it's really good to see you. So I don't know why they ended up at the very low ranked school that they did. But their quality of legal representation we have seen indicates that that's the option that was available to them, at least to me. And that also, I have questions about why Janet is licensed in Illinois as opposed to California, which is where she appears to reside, which appears to be her state of citizenship. And California has a notoriously difficult bar exam. It's number one, they don't use the UBE, the Uniform Bar Exam, which most states do now. And they have it's a 3-day law or bar exam instead of a 2-day. It has a full third day on California specific law. And it has a very low pass rate. We're looking, really, really good schools like, UCLA, USC have 80, 85% pass rates, which is pretty low. But you have, the Lincoln School of Law that has, 20%, 30%, and various others. And it just there. I have a feeling that Janet, recognizing she was going to practice as a federal attorney, she knew that she could pro hoc into whatever federal jurisdiction she needed to, and she didn't even need to pro hoc. You just have to pay the admissions fee, and she'd be good. She could do a nationwide practice. That's what a lot of copyright attorneys do. But we'll get into the way she appears to have done it could be an ethical problem. And that's it, Jillian. It could be the first bar exam she took was Illinois, but it could also be, I mentioned the UBE. I looked up the scores yesterday. So Utah, the minimum passing score is 270. The lowest passing score in a state is Minnesota, Missouri, I think, and a couple others at 260. Illinois is 266. And so, like, for some of my friends that didn't pass here in Utah, they had a passing score in Minnesota. So they're like, well, I'll take it one more time. And if I don't pass, I'm going to apply in Minnesota because you've got a passing score in Minnesota. You've just got to pay the fee and pass character and fitness there, and you're at least admitted, and that opens more opportunities. But I have a feeling that with Janet, she, it might have been, well, I can get licensed in Illinois. She definitely could have in Minnesota and a few others, but she might not have been able to in California. It basically is the point. And so federal attorneys, once again, what is a federal attorney? I think the way you are interpreting it by saying most of them, are New York, DC, and California licenses, you're interpreting federal attorney to mean employees of the federal government. And that's probably the way I'd interpret it too, because as I've said, it doesn't, saying I'm a federal attorney because I'm a member of the federal bar. Whoop-de-fucking-do. But most attorneys who work for the federal government are going to be working in DC, New York, California, just Texas maybe, just because that's where most of the federal agencies are. But the reality is the federal government, if you work for them, any bar will do. So lots of them, because DC was either 266 or 260, I can't remember. But so like lots of assistant US attorneys, they'll get the DC bar and then practice here in Utah as a federal prosecutor just because it works. It's good enough. And that's it. Most states, as long as you're a member of a state's highest court, that would be the Supreme Court here in Utah, the state Supreme Court. As long as I'm a member in good standing, I can apply for membership in most federal courts, to practice in most federal courts. But some I would have to get local counsel or do it pro hoc vice, but I could practice in most of them. And that's basically what Janet is doing. But there's a problem with the way she's doing it, I believe, assuming she lives in California. So and there was a comment. Puzzled to pieces. Have the defendants been served yet? I think so. So the summons was issued as to all the defendants on the 8th and the 10th of January. It doesn't, we haven't seen it filed though. It's just a docket entry. So I'm assuming they've been served. It looks like they've been served, but I don't have all the information I want as to whether or not they have been served. So basically, as I mentioned, we're going to discuss this minute entry, which is docket number 6, which was filed on January 17th. But we're going to click through and look at the PDF of it. This says the exact same thing it says on the docket, but the PDF is just bigger. So we're going to do it that way. And so this docket entry was made by the clerk on Wednesday, January 17th, 2024. Minute entry before the Honorable Mary M. Rowland. In light of plaintiff's invocation of diversity jurisdiction as the basis for federal jurisdiction, on or before the 31st of January, 2024, plaintiffs shall file a jurisdictional supplement as a separate docket entry. So that's commanding. They shall file. And yeah. As to Plaintiff Braun, plaintiffs are reminded. Boy, that's strong shade there. That's plaintiffs are reminded. That's not a friendly reminder. That's, listen here, numbnuts. You should know this already. The court can't say that in a filing, but that's what it means. So plaintiffs are reminded that allegations of residence as opposed to citizenship are not sufficient to establish diversity jurisdiction. And that's quoting Slotky versus Wisconsin Department of Workforce Services from the Seventh Circuit in 2018. And that's it. You never want to be reminded. It really is about as brutal as it gets before a reminder about Rule 11 sanctions. It's just that bad. And, 20s. Yeah, that's pretty normal here in Salt Lake, although doesn't get as cold in the winter as it used to. It's funny. I argue with my cousin's fiance because last year, officially, the record book was broken. Salt Lake City received more snow than it ever has in Salt Lake City for one winter. And I argued with her, yeah, but that's one location, and specifically the airport, which is, frankly, it's a good location for the airport because it's about the lowest elevation right next to the Great Salt Lake, so it's swampland that wouldn't be nice to live on anyway. But it gets the least snow. Where I live, 300 feet higher elevation, and I've had at least 3 snowstorms in my lifetime here that have been between 3 and 4 feet of snow overnight. And so it's just, yeah. Why did you have to give me that squirrel to chase? But yeah, that judge, as you know, I don't discuss politics, but this isn't politics, this is law. And Trump's judge seems to need a lot of reminders. She's not good. But yeah, so going back, that quote was from, as I mentioned, from Slotky versus Wisconsin Department of Workforce Services. So let's take a peek at Slotky. And so Slotky argues generally that his complaint meets, in quotation marks, meets the requirements for diversity jurisdiction. The district judge concluded that diversity jurisdiction was destroyed because the Department of Workforce Services is an agency of the state, which is not a citizen for purposes of the diversity statute, and because Slotky alleged that both he and Harrington, another defendant, reside in Wisconsin. But a person's residence may differ from his or her citizenship, domicile in parentheses, and it is diverse citizenship that the diversity statute requires. Nonetheless, Slotky failed to plead the citizenship of Harrington and the Fireman's Fund. And when the parties in the diversity suit allege residence but not citizenship, the court must dismiss the complaint. So there you go. Jeanette alleged part-time residence. But as this court said, as the Seventh Circuit said, when the parties in a diversity suit allege residence but not citizenship, the court must dismiss. So basically, yeah, as it stands right now, the court must dismiss. of course, the court is saying, hey, file a jurisdictional supplement and let us know. But yeah. And that's it, static. Where you live in Utah, like when I was a kid, I remember my house got the lake effect. It seems it's shifted to your house for some reason. And my theory, of course, is that Farmington Bay is no longer a bay, it's mud. So there you go. And as I mentioned, the residence, the domicile is where do you intend to return? And that could, that there's a number of factors that go into it. It's like I mentioned earlier, where do you have a driver's license? Where do you live? Where do you vote? Where are your bills sent? These all go into it. So, like, as an example, growing up, my family has always been into whitewater rafting, and we have historically gone to the Snake River just outside of Jackson Hole. I mentioned earlier, I know Wyoming exists because I've been there many, 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 many times. And my one of my desires, late teens, early 20s, was I wanted to be a river guide on the Snake River. I never did because I'm kind of too lazy to have done that, but I wanted to be a river guide on the Snake River. So that would have meant spending the summer as a resident of Wyoming. Although I could have been a resident of Idaho because it's that close to the border. But my domicile would have still been Utah because I would still intend to return here for 3/4 of the year. I would still vote here. I wouldn't change my driver's license for 3 months of work. It just, yeah. And I don't have confirmation of any of this, but it would appear that Janet's domicile might be California. And once again, I don't have confirmation of this. It's Ian Runkle. Go subscribe, Runkle of the Bailey. He's great. He's very kind and very knowledgeable, even if he is Canadian. But he mentioned in his video yesterday that Janet has apparently had some legal problems in California, and she is maybe going through a divorce in California. Now, as you know, I do not practice family law. I steer clear of family law. It's not something I want to do. But one thing I do know about family law is you have to have jurisdiction to go through a divorce. The court has to have jurisdiction to grant you a divorce. And what court has jurisdiction to grant you a divorce? It's the court where you are domiciled. It's the court where you are domiciled. So there is a great big caveat there. At least one party to the divorce has to be domiciled there. So Janet might have already established her domicile outside of California. She might have already moved, but her estranged husband still being domiciled in California, their marital home being in California, that could be the jurisdictional hook. But I don't know. And I'd be very interested to see the pleadings from the divorce case, because just like let's go back to the complaint. There is going to be in the complaint for divorce and the petition for divorce, there's going to be a similar statement of the parties like here. So if Janet's ex, like I said, I don't have any details. I don't know who filed for divorce. But if Janet's ex says Janet is a citizen of the state of California, that's pretty good proof. But if Janet has pled in her divorce that she's a citizen of California, boy, is she in trouble here. So what can she do to fix this? What can be done to fix this? And Jamie Grayson, it's real good to see you here. I know it sucks for you to be a party to all this, but I hope you are at least getting entertainment from this. And yeah, if I were in your shoes, I'd probably have already been looking for a lawyer, because I believe you've suffered damages and have a valid lawsuit, but I don't give legal advice on here. So, but yeah. So there are, I believe, a few very easy fixes to this. Although, and normally I wouldn't give the very easy fixes here, because, Lauren wouldn't know them, and Janet and their attorney seem to be such terrible attorneys, they might not know the easy fixes. And so I don't want to give them hints, but in this case, I feel comfortable doing it, because doing these easy fixes would be colossally stupid on their part. And so the first easy fix, of course, is dismissing voluntary dismissal and filing it in California state court. But that would be stupid, because California has such a strong anti-SLAPP law that they're going to lose. But my favorite, very easy fix is I mentioned the sources of federal jurisdiction. Now, this wouldn't fix any venue problems, because Illinois, if Janet is a citizen of California, that means Braun Law is a citizen of California. And so there is no nexus in Illinois. So there's no jurisdiction, and it's an improper venue. But so this doesn't fix that. But if they want to keep it in federal court, there is a very easy fix, but it would be a colossally stupid fix. And I'm going to let my attorneys in the chat tell me. I'll give you the fix, but I want the attorneys in the chat to tell me why this would be so stupid before I confirm that's what I'm thinking. But the easy fix, as I mentioned, there are various different sources of federal jurisdiction, and one of them is federal question. So it's based on federal law. And so even before this clusterfuck of a lawsuit, the whole mess was copyright, and copyright is federal law. So they could simply file an amended complaint and include claims for copyright violations, and then that would use what's called supplemental jurisdiction to keep these claims, the defamation claims, with the copyright claims. And so it's kind of, it's sometimes, supplemental is sometimes referred to as piggyback jurisdiction. So it's state law claims that you wouldn't be able to get in because there isn't complete diversity, but they arise out of the same transaction or occurrence, and it makes sense to hear them together so you can bring them alongside the federal claims. So why would that be colossally stupid for them to do, especially for Janet? Especially for Janet. There is that. There is that. Although the damages are capped. Well, the statutory damages are obviously actual damages, or up to, I think it's $175,000. So that would still be worth it. And that's it, Jillian. That is exactly right. Janet is the counsel of record on the copyright claim. She already has probably waived, well, Lauren has probably already waived attorney-client privilege between her and Janet. But if they were to bring the copyright claims, especially as co-plaintiffs, Janet could kiss her bar license goodbye. It would be that big of a conflict. It would be nuclear. It would be hilarious. It would be hilarious. I would absolutely love to see it. And that's it. They do seem dumb enough to try. They seem dumb enough to try. So, but then there's also, I mean, most SLAP laws have provisions for fee shifting, for payment of attorney's fees to the prevailing party, but the copyright law does too. Although it's not required, but it often will result. Annoyingly, for those of you who have followed this channel for a long time, you'll know Delete Laws wasn't ordered to pay attorney's fees in DeCastro versus Abrams. Part of that is probably he was pro se, and he's presumably collection proof anyway. But then you look at the Sargon of Akkad. What was that? Aquila Hughes versus Sargon of Akkad, and Aquila Hughes had to pay Sargon hundreds of thousands of dollars in attorney's fees for bringing a copyright claim that, it wasn't even settled law that would have been fair use, because to my knowledge, there was nothing additive. It was just clipped. So, but like, I don't know that was even settled law as far as fair use goes. But she had to pay an assload of attorney's fees. And, Janet, well, part of the calculus that goes into whether someone does need to be paying attorney's fees is, just how frivolous is the copyright claim. And Janet, being a copyright attorney, makes it all the more frivolous. And Lauren, the mortician, bringing false copyright claims represented by the world's worst attorney, she should have known better. Her attorney should have counseled her, this is not a good claim. This is fair use. So it's bad. And Spicy Love, he is not very experienced to my knowledge. He has 4 or 5 years of experience. He went to the same terrible law school as Janet did and graduated about the same time. I'm not impressed by the quality of his work. Now, I make no claims that I'm a great attorney either. I'm here on YouTube, but I definitely recognize good and bad legal work, and this is terrible. Of course, Janet's is even worse. You know, so you wouldn't realize this unless, of course, you do live streams yourself. But by the end of a 3 or 4 hour live stream, I get pretty loopy because you'd think, oh, that's just, you know, a third of a day's work or half a day's work. You should, you know, you should have expended about the same amount of energy as doing half a day's work. But a 3 hour live stream feels like you've done overtime. It feels like you've done a 10-hour shift. And so by the end of the last live stream I did covering this case, I was pretty loopy and I forgot the punchline. And the and that was going over the cease and desist that was sent to Caffinated Kitti by Janet. And basically the punchline was, you know, why is this not defamation? Why is this defamation case frivolous, at least as concerns Janet? It's because a reasonable person would see that cease and desist and they would say, is this person serious? Are they an actual attorney? Because a reasonable person would have questions about that cease and desist. They would not believe it came from a licensed attorney. A reasonable person would call them out on it. And so it cannot be defamation. It's, especially if you look at it, you know, Janet, at least being somewhat of a public figure, you know, a limited public figure for the purposes of her TikToks, she might, you know, the heightened public figure pleading standard might apply. It might not. I don't know. But assuming it does, you know, did Caffinated Kitti and the other girlies as well, because they all commented on it, you know, saying, is this really a lawyer? Or, you know, it's not reckless disregard for the truth. It's a serious case of, I have questions. I have major questions. And this is just so bad. Ooh, I didn't know that, Jillian. And so Jillian, for those of you who are just listening, says that The address listed on the complaint for Braun Law, so for the law firm, is a UPS store mailbox. So this is where I mentioned before that Janet could have major problems here. And so we've discussed to practice in federal court, what you need to be licensed before the highest court in a state, and you need to basically take the oath, pay the fee for federal court. And yeah, that's what you need. And you can pretty much, with depending on the local rules for each of the federal courts, you can have a nationwide federal practice. It's, it's what Leonard French, Lawful Masses, does. He's your favorite copyright attorney, and he hasn't made videos in a while. I think he'd love this one. He needs to cover it, but he's covered, he's done cases nationwide. Richard Leibowitz, Leonard French's favorite lolcow copyright troll attorney, well, disbarred attorney now. He was disbarred in multiple jurisdictions because he had a nationwide practice. And that's what Janet is doing. But Janet could be doing it wrong. So one thing lawyers need to do is we need to do what's called continuing legal education, CLEs. And so here in Utah, I have to do 12 hours of CLEs every year. And I need an hour of ethics, an hour of professionalism, and 10 more general. And the basically, Calico Bell, I'm sorry that you've had to deal with her like that. I saw someone comment about Janet potentially having done sex work before. Can't remember if it was a CC Suarez video or someone else's. But yeah, that's terrible that she has terrorized any community, frankly. But sex work is work. It's valid. It should be safe. Yeah. But yeah, so basically, a couple of the CLEs I took late spring, early summer this year actually dealt with, is it even appropriate anymore to limit practice to certain states? Should the practice of law just be nationwide? And this CLE was put on by the American Bar Association, just a online webinar. It's I know sovereign citizens, the ABA is a boogeyman that, it's like, yeah, but it's a professional association that's a source of cheap CLEs. But so it was presented by a number of attorneys who, that there was a New Mexico bar commissioner, or can't remember if he was the bar commissioner or if he was the disciplinary council, because the state bars have discipline council. So basically, if I'm alleged to have committed malpractice, what happens is the state bar discipline council essentially acts as prosecutor, and they try me before the Utah Supreme Court, because the state Supreme Court regulates lawyers, so they have original jurisdiction to hear lawyer discipline matters. And basically, puzzled to pieces, this could very well be a license in jeopardy situation. This of course is also a bit of speculation on my part, but it is an educated speculation nonetheless. So, and then I think it was a Wyoming and a couple other, and they were all either bar commissioners on the rulemaking committees or the actual disciplinary council for the bars. And they generally were in favor of nationwide practice, but there are a handful of issues, let's say, that need to be figured out to make it a reality. And one of those is, as we just mentioned, the state Supreme Court has the regulatory authority, the punishment authority over lawyers. And the state bar pays for that prosecution out of bar dues paid by lawyers. I often complain about the extortionate bar dues, but the reality is it pays for a lot of stuff that go towards regulating lawyers. And another thing that is paid for out of bar dues at the state level is basically the legal equivalent of uninsured motorist coverage. And so if a client is damaged by an attorney's malpractice, the state bar has essentially a victim's compensation fund. It's not going to make you whole necessarily. That's what legal malpractice insurance is for, but it pays victims. And so that's one of the questions here. But they also, part of it was, part of the discussion that they had was, well, what happens if if I'm licensed in Utah and I decide, I am a very expensive lawyer, and Utah's state income tax, as minimal as it is just too much for me to bear. And so I am going to move to Wyoming, which has 0 state income tax. And as you know, well, Jackson Hole is one of my least favorite places because it's full of what I call Connecticut cowboys. It's an awful place. But around Jackson Hole is my favorite place on earth. One of my dreams is I would love a cabin in northern Star Valley. If you know where Alpine is, right at the bottom of the canyon, right on the border with Idaho, that's kind of my dream, is have a part-time residence there. But let's say I'm running a nationwide plaintiffs law firm doing mega lawsuits. And so financially, it makes sense for me to move to Wyoming. Although this guy is from Wyoming originally, but one of the all-time most famous plaintiffs lawyers is Jerry Spence. And he lives in Dubois, Wyoming, right outside of Jackson Hole on the other side. But like I said, he's from Wyoming. But yeah. So the question is, if I am traveling around the country suing as a plaintiff's attorney, does it matter that I live in Wyoming and I'm licensed in Utah if I'm suing in Texas and in New York and wherever, and mostly in federal court, but everywhere else that I'm pro hoc vice, have local counsel, following all the other rules? It probably does matter. And what one of the exceptions allowing you to practice in a state with an out-of-state license is if you have a single client. So corporate lawyers, if I get hired by Google, I can practice in California on my Utah license because Google is my only client. I'm an in-house counsel. But for that, I would have to register in California as an in-house counsel, and I'd have to pay a fee. It's less of a fee than full-blown California bar membership, but it would allow me to practice there. And so basically, what happens is if I'm licensed in Utah, live in Wyoming, and even practicing remotely, even if it's Utah clients, there's the question of, if I commit malpractice, which bar prosecutes me? Is it the Utah bar where I'm licensed and have paid my dues? Is it the Wyoming bar where I'm living, where I'm doing the actual work? Let's say I am licensed in Utah, I'm living in Wyoming, and my client and the lawsuit itself is next door in Montana, and I commit malpractice. Does Utah, Wyoming, or Montana hold me responsible? But it's not only that. Who pays for it? The Wyoming bar that I haven't paid dues to? Does the Montana bar use their victims' compensation fund to pay my client that I committed malpractice against? Or do they have to come to Utah? So the reason I bring this up is because Janet presumably lives in California. She does the work in California. Her license is in Illinois. She has paid the Illinois bar. In this case, her client is in either Wisconsin or Florida. We're going to say Florida. And this is for the copyright claims. We're looking at malpractice as to the copyright issue. The can't remember his name. Lockyer, who is an Illinois attorney and presumably in Illinois, would be the one on the hook for malpractice in this actual lawsuit. But for the copyright claims, Janet's client is in Florida, presumably. The damage has been felt, presumably, in Florida. Who pays? Florida or California? Who punishes her? Who punishes Janet? Florida, Illinois, or California? the CC Suarez, and I still want the correspondence between CC Suarez and Janet, the Bunny XO clusterfuck, because that'll be fun. But Bunny XO lives in Nashville, I believe. So that, assuming Bunny XO is telling the truth, Janet was going against client orders. She was, as some may say, a rogue attorney. So does the Tennessee bar punish Janet? California, Illinois, who? That. But this could lead to charges, though, of the unauthorized practice of law. Because, like I said, even though she presumably has followed the rules to be admitted to practice in all of these states, with her, that's, I think, an awfully big presumption. But we'll give her the benefit of the doubt there. We'll say that she has followed all the local rules for admission. But the fact that she is living in California, practicing in California, doing the work in California, California may very well find that she has engaged in the unauthorized practice of law. Even attorneys can engage in the unauthorized practice of law. It's something we have to look out for. I've mentioned my hypotheticals, but what happens if I am licensed in the state of Utah? My client is in the state of Utah. I am that client's lawyer. I handle all their transactional matters. I handle their litigation for their breaches of those transactional, matters. And so let's say for my Utah client, I negotiate a contract with a company in Wyoming. And that Wyoming company breaches that contract. But the terms of that contract say, because contracts are generally going to have a jurisdictional section. So that contract says any breach of contract has to be litigated in Wyoming. I am representing my Utah client. If I sue in Wyoming for my Utah client, am I engaged in the unauthorized practice of law? Maybe. There's a pretty good chance, actually. But negotiating based on Wyoming law for my Utah client here in Utah, have I engaged in the unauthorized practice of law? Maybe. It's some of these are more cut and dry than others, but this is just to show you what a clusterfuck you can run into when you're practicing across state lines. And that's it. For the litigation, I probably would get a local counsel and pro hoc vice. But for the negotiation of the contract, that alone might have been, depending on the facts, it might have been pushing the line. But it might not, because these are all fact-intensive analyses. So basically, once again, the punchline is, has Janet engaged in the unauthorized practice of law? Maybe. And if she has, this could be career ending. Of course, it could be a slap on the wrist as well, but it's not a slap on the wrist I'd be wanting. You know, I don't kink shame, but this isn't the good kind of slap on the wrist. So I wouldn't want it. So that's basically where we are with this. So let's switch. Oops, didn't want that to autoplay, but could you hear when it did autoplay? Waiting for the chat to tell me if you could hear the video. But yeah, so like I said, just a reminder, I do want to cover CC Suarez nonsense. So if anyone's able to send that to me, or Jamie Grayson, since you're in here, I don't know if you have contact with CC Suarez, but you know, if you tell her to email that to me, I would be eternally grateful. Okay. Well, let's stop sharing and then re-present it. All right. Thank you, Jamie. Obviously, you rock for a lot more reasons than that, but for that too. So, all right, let's make that big and let's dive into this. So this is Caffinated Kitti's video, obviously, as you can see. It's her video of the wellness checks that were phoned in, and normally I have to make sure that I comply with fair use. You know, some people would say I go overboard and I stop too much, talk too much, but you know, I'm a commentary channel. It's what I do. I have a feeling though, Caffinated Kitti would grant me license. So I'm going to try not to jump in as much as I normally would. Of course, probably still will be fair use, but let's jump into it.
App Lauren, the Mortician, has hopped up and admitted to calling in a wellness check on me. A good day to you. My name is Kitti and I'm a gun life coach coming at you live from inside my coffin to discuss those calls. Because what's so fascinating to me is she's hopped up here and claimed that the reason she did it was out of a genuine concern for my mental state, my well-being, and my life. Because I was talking about drinking blood to survive and eating organs and doing demonic things. Now, keep in mind that a literal simple Google search of my name would pull up several different types of articles that all give significantly easy to find context on why that might be something we discuss on this very macabre and satirical page that I run here.
So, I know I just said I won't stop quite as much as I normally do, but once again, let me know if you can hear it now that I pulled it up. But as far as eating organs go, I don't know if I have any Scottish viewers in here today. I know I do have Scottish viewers sometimes, but eating organs, she doesn't even specify, as far as I know, that they're human organs. And so for those of you up in Scotland, do you get wellness checks when you eat haggis? For those of you who like liver and onions, do you get wellness checks? Steak and kidney pie. Do you get wellness checks? I didn't think so. I didn't think so. And Kitti says right here. Now, I realize this is after the wellness checks because, I realize timey-wimey, wibbly-wobbly, but this came after this video came after the wellness checks since it's audio of the wellness checks, but I believe it came before the lawsuit. So basically, in the lawsuit, the morons took it as if everything she said was matter of fact. And she even says right here, yeah, this is satirical and these morons don't get it. And that's it. Some of those, as many of you know, I did my master's in finance at Durham University. I just couldn't do some of them. My friends were very happy to sit next to me on Burns night and scoop the haggis off my plate. The neeps and tatties were lovely. The roast was lovely. I just couldn't do the haggis. I'm a picky eater. So yeah. But that it's relatively trendy for women to eat their placenta or dry it, powder it, put it in capsules. Is that worth a wellness check? Is that cannibalism? Is that weird? Well, I mean, I kind of think it's weird, but I'm not judging people who do it because it's what people do. It's yeah. I mean, Linux guy, that certain scholar would have sued anyone that called in a wellness check on him, even if it were a legitimate wellness check, shall we say. But let's keep going.
But also, what I find the most fascinating is that the call and the reasoning are entirely different. What she told the police does not have anything to do with blood, organs, or any of the like. As an unfriendly reminder that this video is for the purposes of commentary, critique, parody, review, satire, and a recitation of the facts to clear up any discrepancies in the situation. And remember that don't go give these creators any form of hate, harassment, or the other thing, because all that will translate to is more cheese for the shit cootery board that they have made here. And
shit cootery board. That's good. And now, for the purposes of YouTube, that's probably a good disclaimer for Kitti to make. Just, look, even if some of this is questionable on the terms of service for YouTube, which I don't think it is, but even if it is, look, this is something that happened in my life. This is something I want made public. This is something I want to talk about. And she doesn't actually need to worry about fair use, though, because, Lauren and Janet are not the ones who fix this into a tangible fixed medium. They don't own the copyright. Technically, the state of Georgia would own the copyright, but it's a public record, so it's probably public domain. And I agree, Jillian, she is a gem. And I realize, according to Janet, I'm supposed to feel intimidated and threatened and all the, she's what's the catchphrase? She's here to traumatize all the men. But I agree, she's a gem. She's lovely.
And I'm more of a meat girly myself. I do like prosciutto, so that is why I like to provide hard evidence. Also, before we show off these calls, keep in mind that me whistleblowing does cost me some IRL fees and such to make sure I'm legally protected against actions. And if you would feel so inclined to join me in my spiteful crusade to make sure this information is out there, you can do so on my Spiteful Fund page, which also gets any of the fun details and updates first.
That's a good reminder. There's the spiteful phase, but there's also I think it's the girlies versus Janet.com. Hint, hint, they've got their GoFundMe. They had their stated goal of $20,000, which they have more than met. But assuming this isn't dismissed with prejudice, assuming it does continue in some court or another, even getting through the anti-slap motion could be six figures. Lawyers are expensive. So, supporting the girlies is appreciated.
Or you can always send me a $6.66 donation to my villainous Venmo. It does go a long way. So those devilish donations aside, only do so if you are actually in like a good place to do so. Like never send somebody anything on the internet if you're not like good, okay? What I find interesting about the calls you're about to hear is the fact that they never actually specifically quote me. They don't say what this blackmail, extortion, and erratic, irrational behavior was. They don't get specific. They keep it relatively vague. And it should also be noted that I made it abundantly clear that I was ensuring that I had legal protection before I whistle blew what I considered to be an abuse of the copyright strike system by a larger creator who had seemingly, allegedly, hired an attorney to do this type of work for her to, in my opinion, get rid of any form of negative feedback, no matter how benign, how constructive, etc. it may be. And we will discuss later why I personally think that that is an incredibly dangerous precedent to set, especially in the case of potential groomers and abusers down the line. Not in their case, but specifically, that is a very dangerous precedent for that kind of reasoning. However, here are the calls. Enjoy. As above, so below. Glad to have you at the shit show.
So this is Puzzle to Pieces says Lauren the Mortician is judging Kitti and her spiritual expression, which is protected by the First Amendment. And it is, but this is a defense that Ashley Giard has tried to make in the TikTok psychic case. My tarot readings are my spiritual practice. And so this bitch up in Idaho that I have said is a murderer because of my tarot readings, she can't sue me for defamation because that's discriminating against my spiritual practice. And that's not actually the case, because you're defaming someone. How you arrived at that defamation doesn't matter. But Kitti, she can allege this is her spiritual practice. So like if the government determined, well, you're harassing her, this language is harassing, and so we're going to charge you, then it might be protected in that way. But this isn't really a freedom of religion case. It is still a First Amendment case because it, freedom of expression, freedom of speech, and yeah.
Hello, my name is Jeanette Braun. I'm an attorney, a federal attorney out of Illinois, and I'm actually calling in a wellness check.
And once again, I'm an attorney, a federal attorney. She's got to get that in there. Got to get in that federal attorney. She wants all the cookies. No, that isn't fat shaming. It's, I've said in the past, ooh, you're a federal attorney. Want a cookie? She wants all the cookies.
Or she's acting irrational and posting really wild things online. It really looks like she's having a mental crisis and needs some help. I'm wondering if you would go do a wellness check on her and make sure she hasn't harmed herself, or
I need an address.
Do something more.
So remember in the cease and desist. In the cease and desist, Janet says to Kitti multiple times, you are not an attorney. You are not the judiciary. You can't make fair use determinations. And she says that to YouTube. She says that to Cece Suarez. She says that all the time. You are not qualified to make the fair use determination. But I, a federal attorney, am. And I have made that determination, but it's attorney-client privilege, so you can't see it. You can't see it. Is Janet, is she a psychiatrist? Is she a psychologist? Is she a mental health practitioner? No, she's an attorney. So is she qualified to say, I think she's a danger to herself. I think she's acting irrational. I think she's having a mental break. Whatever other nonsense she said there. Just saying. If Caffinated Kitti isn't qualified, if Google and their attorneys aren't qualified to give an opinion on fair use, why is Janet qualified to call in a wellness check and give her opinion on someone else's mental health? Pot kettle is all I'm saying. And there's going to be several more pot kettle situations in this call.
Sure, the address is, I have it. Coming now, I have to pull it up. And what's her name? Her name is she black?
So just going back on information and belief, CK lives in Georgia. You gave her name. You gave her address. So why did you plead it on information and belief? This is just dumb. And that's actually smart, Linux guy. It's not a complete protection, but like I was just last night I was watching a Turkey Tom video, his breakdown on Dark Side Phil, and apparently Dark Side Phil was getting doxxed. Well, he was getting swatted, but he preemptively, when he moved into his house, he talked to the local precinct. He said, so I live here. I live stream every day. Live streamers get swatted. So if you get a call about me, it's probably a swatting attempt. And so it's not an absolute protection. The cops are still probably going to show up, but if it stops them from showing up, guns drawn, that's a win. It's at least an added layer of protection. So
Black white with short. Do you have a date of birth on her? It is February. It's February. I don't know the date. Whatever is a good one. 19. And what exactly is she posting? She is posting on her TikTok under Caffinated Kitti, CAFFINATED and her Reddit account. I just need to know what she's posting. I don't need the usernames. Oh, she's blackmailing people.
Oh, there it is. She's blackmailing people. Janet, you're not a prosecutor. You're not a judge. Are you qualified to say someone is blackmailing someone? I mean, clearly you're not qualified to give an opinion on blackmail because apparently you don't know what blackmail is. Because according to her, blackmail is Caffinated Kitti responding to an unhinged cease and desist by saying, so I realize you might be an overzealous fan, but this isn't going to reflect good on Lauren the Mortician sending this crap out on her behalf if you don't represent her. That's not blackmail. That's not defamation. That's not harassment. That's just good advice. Because ignoring the law, a competent lawyer in this arena would understand the rules of social media. They would understand that sending out deranged cease and desist letters and false copyright strikes, even slightly questionable copyright strikes, even copyright strikes that you might actually win, but are going to piss off the community, are a bad idea, are going to reflect poorly on your client. That's just good advice, not blackmail. It's not blackmail. And Static, I don't know. I can't see how she'd believe any of this, but maybe she really is just this dumb. Of course, I do think she, if she's a pro at anything, it's gaslighting, because we've seen the quality of her legal work. It's terrible from everything we've seen. Now, I haven't looked her up on Pacer. I haven't typed in Jeanette Braun on the council line in the search. So I don't know if she's brought any lawsuits as the attorney of record, or if she just is the attack dog sending the cease and desist letters, hoping that she can intimidate the defendants into acquiescence. Because I have a feeling she doesn't actually litigate these copyright claims. She seems to be basically a bully, and her tactic seems to be the gaslighting bullshit, the puffing out the chest, and I've done the analysis, but I won't tell you the analysis, but I've done it and I'm right, and therefore you need to take this video down because it's infringing the copyright. It's not fair use. And she thinks if she can bluster enough that non-lawyers are going to be intimidated. And I'd qualify that as a form of gaslighting, and I think that's her practice strategy. But the minute someone hires an attorney, that attorney is going to laugh their ass off and then absolutely destroy her in court, assuming she actually files. Now, there, of course, is the danger. Cece Suarez, who had her video struck by Janet, struck by Bunny XO, with Janet maybe doing it as a rogue attorney. We don't know. According to Bunny XO, there was no instruction to do so. Although I'd have to see the contract between Janet and Bunny, because it could be that, the contract basically said, sick, go after them. You don't need my permission. If you see a copyright infringement, take it down. That could be what the contract said. And then Bunny XO is basically like, well, the contract might have said that, but I didn't tell her to take this video down, even though the contract allowed it. But the reality is, Cece Suarez has suffered damages. She could sue Bunny XO. And Bunny XO is not collection proof. She's rich. Her husband is rich, that being the singer Jelly Roll. Of course, if they're smart, they've protected their assets in some way, and so maybe you can't get at all of their assets, but and so let's just hypothetically say Cece Suarez sues Bunny XO and wins. Well, that was such a frivolous copyright claim copyright strike that cost Cece Suarez damages, because 3 strikes and you're out on YouTube, although YouTube pretty much said, yeah, this is a false strike, so they didn't count it. But it causes damage. It causes damage. And so, Bunny XO could have a claim against Janet for malpractice. How's your malpractice insurance, Janet? I hope you're paying your premiums. And let's see. That's what I'm looking for. Calico Bell. It's basically lawyering 101. You don't take offense as a lawyer on behalf of your client. The opposing party is going to talk bad about you. They are going to be upset about your behavior. They are going to call you unethical and, whatever. And you take it. I mean, you pretty much expect at some point in your career, if you're in civil litigation, the other side is not going to like you. And you can count at some point in your career, the other party is going to file a bar complaint against you because they think that you representing your client is unethical, that you are harming them. But I don't owe a duty to, well, at least not a fiduciary duty to the opponent. I don't have to have them like me. In fact, if they hate me, if they call me a no good, rotten son of a bitch, I'm probably doing my job. Janet should have worn it as a badge of honor. I mean, in her case, she's such a terrible lawyer that it actually is the truth that, she's terrible. But instead of suing for defamation, I'd put a part on my website. I'd put a page, the most lawyers have the results page. I'd put the anti-results page and brag about, this opponent thought I was a no good son of a bitch. This opponent, called me, the devil incarnate. I'd wear it as a badge of honor. If the opponent doesn't like me, good. Good. I don't want them to like me. I want to win for my client.
She is going, she's extremely irrational, posting content to threaten others. She's looks like almost extortion. I received an email from her on Saturday that was full of blackmail and extortion, and I'm going to submit that to the FBI, but now she's posting online, and she really seems to be having a mental crisis. Is this a relative?
Once again, a mental crisis. Are you qualified to determine that? But also, well, this isn't publishing it, but by Janet's terrible legal logic, could Caffinated Kitti sue for defamation here? No, because while it's a defamatory statement, it's not published. Kitti published this herself by requesting the audio of the call. But calling in a false wellness check, could she sue her for harassment? Sue her for, get a restraining order, get whatever. Calling the FBI for this? Once again, lawyers are held to a higher standard. So if you're calling the FBI and saying this is criminal, maybe Janet needs to be looked at for calling in false police reports, for filing false criminal reports. Maybe the FBI needs to be looking at Janet.
Relative of yours, or no, not a relative. What's your name? Jeanette, Jeanette, and my last name is Braun, Braun, and I'm an Illinois barred attorney. I think I have an obligation to report when I see erratic behavior as an officer of the court, and this is.
No, you probably don't. In fact, you probably shouldn't, unless you're seeing an actual crime, like we're talking witnessing. Her saying, as an officer of the court, I think that I have an obligation to. No, like, I think what she's interpreting this as is, let's say I'm representing a criminal defendant. I'm a criminal defense lawyer. And if I know that my client committed a crime, I cannot turn them in. If they come to me after they committed a crime, but haven't been charged, and they say, Joe, I just shot the sheriff, but not the deputy. I shot the sheriff. I know that. I cannot turn them in. That's privileged. Absolutely privileged. But let's say they come to me the day before and they say, Joe, I'm about to go and shoot the sheriff. I think he's a no good son of a bitch. Well, then I'd have an obligation to call and say, so so-and-so's on their way to shoot the sheriff. You should probably take precautions. So I have a duty to prevent crimes. To prevent my client from committing a crime. Now, if my client said, Joe, I'm about to go shoot the sheriff, what would be the best way to go about it? If I give advice on how to do it, well, then I'm a co-conspirator. conspirator. And I could be in big trouble myself. So, yeah. But as far as this, I feel as an officer of the court, I have an obligation to say, she's doing unhinged things. No, you don't. No, you don't.
Extremely erratic.
All right, we'll get someone up there to check on her.
Let me get you her apartment number. I have it. I gotta pull it up. I don't have the apartment number. She's on the floor. She was born in February.
Okay.
She's on the floor of the apartment building. Short purple hair, thin, white, and I think she really needs some help.
All right, we'll get someone up there to check on her.
What Janet didn't say is the help she needs is a defense attorney. Well, maybe a plaintiff's attorney as well, because she needs legal help. Not this.
I appreciate it. Thank you so much. Have a good Sunday.
Okay. You too. Bye-bye.
Bye.
Place of fire.
Hi, I was calling. I was calling to ask for a wellness check on someone.
Okay, what's the address?
It is.
And what's your name?
I'd like to remain anonymous if I could. I know that's awkward, but
So if I'm law enforcement, if I get a wellness check and they want to remain anonymous, what's my brain going to think? What am I automatically going to think? I'm going to think, if they are wanting to remain anonymous, are they calling this in for legitimate purposes? Is this for harassment? Is this a swatting? Is this harassment through law enforcement? Because if I'm calling in a legitimate wellness check, you bet I'm going to co-sign it. I'm going to stamp it in big red letters that I called it in. Because, if you're legitimately trying to help someone, you'll let them know you're trying to help. But if you're trying to harass, you're going to be like, no, it wasn't me. Wasn't me. It was Shaggy, but it wasn't me.
This girl is just spiraling.
Okay. You're gonna have to give me something. What's the relationship?
So she has a presence online, and she is blackmailing people online. She is threatening.
Whoa, blackmailing people. Now, once again, if Caffinated Kitti isn't qualified to give an analysis of fair use, Janet clearly isn't qualified to give an opinion on blackmailing. But how the hell is Lauren the Mortician qualified to give an opinion on blackmail? I mean, of course, she swerved so far out of her lane as her TikTok career that it's not surprising. But, apparently she thinks, or at least she tries to portray, it would seem, that being a mortician or a mortician's assistant or whatever is equivalent to being a medical examiner. Or, Jamie Grayson, a child transportation safety engineer, whatever the title is, I can't remember. But, stay in your lane maybe and don't give opinions on blackmail. That would be nice.
People. She's on Reddit. She's on TikTok. She's acting erratically. Her comments online are wild. I think this girl is literally. Her name is.
Do you have her date of birth?
I don't, but I know she was born in February. I don't know the day.
Well, happy upcoming birthday, Caffinated Kitti. We're not in Georgia or in Germany, so that's not bad luck.
Okay, and what has she been doing online?
She is leaving comments, threatening people, blackmailing people. She's on Reddit, trying to gather people together to go after people. She's
Are these
just acting.
people you or someone you know?
No, somebody I know online.
Okay.
Yeah, she's acting irrational, erratic. And honestly, I just wonder if her mental health is okay. Like, so she isn't gonna harm herself or other people, because this.
Did she mention anything about harming herself?
No. That tells you all you need to know. That's all you need to know about this wellness check from Lauren the Mortician. I think she's going to harm herself. Has she said? No. Good. See ya. Goodbye. No action needed. This is such nonsense. And since I have you here, Jamie Grayson, so Lauren the fucking Mortician is a mom. So she knows better than the experts about which car seats are safe. You know, as most of you know, I don't have kids. I have a niece and 3 nephews. I wouldn't presume to know how to install their car seats by virtue of being their uncle. But she, bitch that she is, the fucking mom that she is, she insinuates bad things about Jamie, which, I can't say the word, like, she doesn't explicitly say it, but she tries to imply on the Bunny XO podcast, especially, things about Jamie that, frankly, are dangerous to imply about people. And since I can't use that certain P word on YouTube without getting demonetized, I have used the word creep in the past, which, once again, I absolutely do not think that about you, Jamie. I think Lauren is terrible to insinuate it. But I was listening to music the other day, and one of the all-time best albums, I believe, is Aqualung by Jethro Tull. And the first 2 songs on the album are Aqualung and Cross-Eyed Mary. And there's a cast of characters in those 2 songs, and Cross-Eyed Mary is a teenage prostitute. There's the schoolboy from whom Cross-Eyed Mary prefers not to get her kisses from, but she prefers the Leching Gray. Or there's the jackknife barber who drops her off at school. But the most important character between the 2 songs is Aqualung himself. He's a tramp who, is a creep. So I think going forward, when I refer to that word that I can't use on YouTube, I'm going to use the word Aqualung in its place. So just reminded me, I have a feeling, not only on this case, but, in other cases going forward, since that's a common, accusation, or at least insinuation on YouTube, on social media, that going forward on this channel, those people will be referred to as Aqualungs, just because, as I said, that's an all-time best album. And so let's continue.
Okay.
But this is just not like her normal stuff at all to be posting.
So you actually know her.
From online.
Okay, but you don't know her personally. You just know her online.
Yeah,
Okay.
yeah.
And you don't want to leave your name.
No.
Okay. All right. Thank
So you don't know her, you don't want to leave her name, you only have seen her online, you don't actually know what her actual behavior is like. And furthermore, going back to other music, let's see, I've got Rolling Stones on today. Half the time it's going to be a Sublime shirt. And furthermore, Janice, I wouldn't be the least bit surprised to know she smokes marijuana cigarettes. Reefer. But this exchange gave the dispatcher everything she needed to know to put, you know, she still has to forward it on to the police, but you know, it gave everything she needed to know to put a note in the file saying not urgent, probably false. You know, she doesn't know her, she doesn't know how she acts, and it's shtick. It's a persona. You know, I'm not going to call in an eating you know, a wellness check on what's his name? I can't think of the voice actor's name, but I'm not going to call in a wellness check on it's Dan Castellaneta, I think, the voice of Homer Simpson. I'm not going to call in a wellness check on him saying, so this guy's addicted to donuts and strangles his kid all the time. And so I really think you need to do a wellness check on him because I'm really concerned. It's a character. It's an act. I mean, Nikocado Avocado, like, I think there's some shtick, but as far as the overeating, that is, you know, that is a worry, but it's not for me to call in a wellness check about. So,
Thank you.
Thank you.
Bye bye.
all right. So there we go. That's the end of it. And just, you know, the thumbnails coming up here. I chastised you guys. Hey, there you go. Sublime. Same in the end. I think that's the best Sublime song. But I chastised you guys on the last live stream I did on this, meaning, which was the second live stream about this case. I said, why didn't you guys tell me that I made the wrong thumbnail? I used Bunny XO, who I thought it was just a glamour shot of Lauren the Mortician, because I don't know any of these people. You know, this is my introduction. And I chastised you guys for not informing me I put the wrong person. Apparently, I'm more of a psychic than Ashley Guillard, the TikTok psychic, because I didn't put the wrong person in my original thumbnail, which is this one right here, Dumb Blonde Sues Critics. It was just a premonition that she would be dragged into this in the very near future. So, yeah. But I have a feeling, though, as I mentioned, where we could be at the beginning of the end of this lawsuit, because, you know, it probably isn't going to continue in its current state unless, you know, she actually has established a domicile in Illinois. You know, best case, it's transferred to California federal court, but it's probably a state court matter. But I mean, you know, that it could get dismissed and then she could just, Janet could just bring the claims on her own. I think the reason she sued with Lauren was basically, if Lauren was defamed, which I don't think she was, but if Lauren was defamed, that defamation looks better than Janet's defamation. And so she wanted that to kind of bolster her claims. But, she could just bring the suit herself without Lauren. That would probably be the smartest move if she wants to continue. But, she could file in California, assuming it's dismissed in Illinois. She could file in Florida, maybe. But, most of them haven't actually, since only Caffinated Kitti, well, Lauren only has a claim against Caffinated Kitti in the current complaint. All the other claims are brought by Lauren or by Janet. So really only Kitti has maybe availed herself of, subjected herself to Florida's jurisdiction. So maybe they all have in Georgia, though, except maybe Bekah Day. But, if there's multiple defendants, it becomes a mess as to if a court has jurisdiction over you when you're not a resident of that state. You could probably bring it in Georgia because that's where multiple of the defendants live. It's a mess. Either way, it probably belongs in either Florida or most likely California. California, it's just going to be an absolute mess for Janet and not even worth the filing fee. Either way, I always feel bad. Like, if it's a frivolous suit, I obviously want the defendants to prevail, get it dismissed real fast, get their attorney's fees paid, and be done with it. But the selfish part of me is like, oh, this is a train wreck. I want to milk it for all it's worth, and I want it to go on and on and on because it entertains me. But that's not what matters. So I see this ending pretty quickly. And I don't see things going well for Janet one way or another. So going forward, when I ended my live stream last Friday, I mentioned we went over the amended motion for summary judgment in the Schofield versus Guillard, the TikTok psychic case. And there was a new filing that had come in, but we didn't know what it was yet. It just had, leave to amend. Well, that's going to be a fun one. So I need to do that soon. There's a few other things, but that's probably going to be the next video, maybe a live stream. We'll see. Either way, I think I've gone on long enough because I'm kind of tired now. Like I said, 2 hours and 23 minutes. It seems, even though it's been fun, it seems like it's been 5 hours because it really is exhausting. But thank you for joining me. Do all the YouTubey things. Like, share, subscribe. Do the same for the girlies. Go subscribe to them. Like their videos. get any social media that Jamie Grayson is still on, subscribe to him there, pay for his pizza, and I will see you guys very soon for the next one. Thanks for joining me. Bye-bye.